In Mineral Area Development Authority versus Steel Authority of India, the 9-judge bench of this court answered the questions referred in terms of the conclusions arrived at by the majority. In the process, the judgment overruled India Cement Limited versus State of Tamil Nadu, and subsequent decisions of this court were relied on it. After the pronouncement of the judgment, counsel for the assessees submitted that the judgment may be given prospective effect. Therefore, the proceedings were listed for hearing submissions on whether or not the judgment should be given prospective effect. We have referred to the submission to the learned counsel, and the conclusion is the submission. I call the judgment MADA because just as a short form. The submission that MADA should be given prospective effect is rejected, bearing in mind the consequences that would emanate from the past period. The following conditionalities are directed to prevail. A. While the states may levy or renew demands of tax, if any, pertaining to entries 49 and 50 of List 2 of the 7th Schedule, in terms of the law laid down in the decision in MADA, the demand of tax shall not operate on transactions made prior to 1 April 2005. B. The time for payment of the demand of tax shall be staggered in installments over a period of 12 years, commencing from 1 April 2026. C. The levy of interest and penalty on demands made for the period before 25 July 2024 shall stand waived for all the assets. We have basically we have said no interest, no penalty. Demands not before the date of Keshwaram. We have taken the financial year after Keshwaram without referring to it.
Grateful.
And third, interest and penalty will be
Grateful.
and staggered payment over 12 years.
Grateful.
Lord, one declaration remains, my lords.
Yes.
In view of this, my lord, now the act should be declared to be valid, my lords. Nothing remains because unless the acts are declared to be valid, we can't collect on it.
But that will depend on
maybe
Other challenges.
So the other request is, my lord, that the matters may be listed at the earliest possible, my lord.
that. First, I'll do it
Because it has been pending since very long time. My lord.
That we will do it.
There are millards,
And from
We don't know.
and from
It will have to be looked into. So
no, I appreciate. So it may be listed at the earliest.
2005.
in some cases, for example, UP Mill, it's already been upheld by the High Court and your Lordship's Court in Keshwaram. So there is no striking
be
down
argued
so far as
before
UP is
regular
concerned.
benches. my lord.
This order will be signed, of course, by 8 learned judges. Sister Justice Nagaratna will not be a party to this order because my sister had dissented in the main judgment.
Correct.
Because this is an order on the state, so naturally this has to be an order of 8 judges.
But silence is acceptance, my lord. I'm sorry for this indiscreet statement. Monam Svikara Lakshanam.
In this case is a reiteration of what I have said. Yes.
there are millards, other analogous matters challenging surface rent, etc., which are not part of this batch. Those matters are also very millards pending since quite some time.
So what you can do is maybe the solicitors junior and all of you can sit together and give us a bifurcation, which are the matter. Then I'll immediately have I'll pass an order on the administrative side listing these matters so that for early exposure, this we are pending for so long.
We shall do that.
ROP could be drawn. So
In view of the dissenting opinion by Honorable Justice P.V. Nagaratna in the main matter, the proceedings are being signed by the 8 judges forming a part of the majority.
Lordship.
Obliged to Lord.
I'm grateful. Please, I'm sorry for the impertinence. my lord.
reminder, right time.
I thought it will come from my Lord Justice Roy.
There's always room for hope. I was hoping that I'll persuade Sister Nagaratna even now. Thank you.
We're grateful to you.